Okay, let's talk a little bit about Supreme Court cases. This video request came from Rachel, and if I couldn't like Rachel anymore, than I did already, giving me the chance to talk about Supreme Court cases, my all-time favorite thing to talk about, definitely makes me like you more. Unfortunately, Supreme Court cases are not a gigantic part of the AP US history test, particularly since they shortened the time frame. There was a lot of stuff in the 60s and 50s, 60s, 70s. They're not going to be on this test. Maybe you can use them for some contextualization, but probably not going to be part of really what we're talking about. So I kind of picked out 5 that I think could make their way on. Some, and I'll try to indicate as we go along which I think have a better chance of working in than others. I would say Marbury versus Madison was a big one, probably more for government than for history. Marbury versus Madison gave the Supreme Court the power of judicial review, which is the ability to review laws. So people can challenge laws in court if they think they're unfair, based on if they think they're constitutional or not. And the Supreme Court can make that judgment if indeed they violate the Constitution. So by giving the Supreme Court this power of judicial review, they made the Supreme Court really powerful. And before that, they were not powerful at all. So Marbury versus Madison in 1803 was a pretty big case. Again, I think that's something you're probably going to deal with a little bit more on the government side of things than now. Might not be a horrible thing to have in your hip pocket, but I doubt it's going to come up. You never know. McCulloch versus Maryland's also another really big one. It's in 1819. It's decided. And really it kind of sorts out how state governments and the federal government kind of coexist. If you remember the story, McCulloch versus Maryland, the United States put a bank in the state of Maryland. The state of Maryland wanted to They wanted to tax the United States bank. The United States refused to pay, and they ended up in court. So the court basically said that the U.S. government is supreme to the state government, or the U.S. law is supreme to state law. So when there's a conflict, the U.S. is going to win the conflict. The federal government's going to win the conflict. And it kind of just spells out what the division is between states and federal government, how they relate to one another. Again, I think that's more of a government thing that we're going to have to deal with, but you never know. These last 3 I could see being on there, and they all have to do with equality. So that's why I could see potentially in a DBQ where you're kind of laying out evidence. Maybe you could pull this in as a source of evidence, because I could see like equality or being the theme of a DBQ. Dred Scott versus Sandford was in 1857. Dred Scott, if you remember, was a slave that was moved from a slave state. His owners took him to Illinois, which is a free state, and basically Dred Scott's like, all right, I'm in a free state, I'm free, I'm out of here. And his owners are like, oh no, you don't. Like, even though it's a free state, we moved you if you were property, so you still remain our property. So there was some legal action in the courts, and the Supreme Court eventually weighed in, and they did side with the owners and said, yes, indeed, if a slave is moved to a free state, they are still property, and that free state can't null and void that property agreement. So in essence, what the thought was and the fear was, remember, this is like 3 years before the Civil War. So the thought was this was a signal from the Supreme Court that the federal government or states had no way to outlaw slavery, that they couldn't forbid it from happening, which isn't what ended up happening in the long run. Plessy versus Ferguson is a very big case in 1896. It establishes the separate but equal doctrine, basically saying that as long as blacks were given equal facilities, it was okay to separate them. So that means if they were allowed to go to school, if they had access to bathrooms and water fountains and restaurants, as long as they had access to those things, you could separate blacks and whites. It kind of paved the way for the Jim Crow laws in the South, segregation. And this is kind of where I said, like, maybe some contextualization comes in, because in 1954, Plessy versus Ferguson was overturned by the very famous Supreme Court case Brown versus Board of Education. Well, that happened in 1954. Again, it's outside the parameters of what we have to know. However, you could kind of bring that in for some contextualization. Hey, this is where the United States went, and this event, again, Plessy versus Ferguson said separate but equals okay, but eventually, like, the Supreme Court reversed field on that, and that was no longer, something that we could do. Okay, so Plessy versus Ferguson is a pretty good one. If you notice, Dred Scott, Plessy versus Ferguson, and the Korematsu case all have to do with equality, so they all kind of tie in together. Korematsu versus the United States happened during World War II. 1944, I believe, was the decision date on Korematsu versus the United States. There was a guy, his name was Fred Korematsu, who was a Japanese American, and he was rounded up and put into the camps for fear of he would harbor some resentment towards the United States, that he was still carrying, like, he's still Japanese, and maybe he deep down wants the Japanese to win the war. So many Japanese Americans were rounded up and put into these camps. Fred Korematsu being one. Remember, a lot of those Japanese Americans lost homes and businesses, lots of money. I mean, they lost jobs because they couldn't go to the jobs. Now, by no means was it like the concentration camps that the Jews had to go through, that the Germans put them in. It wasn't related to that. But on the flip side, anybody saying, well, it wasn't that, I would also say it wasn't exactly like it was the Four Seasons. They weren't like put up in these elaborate, nice places. They weren't beaten, but they weren't given kind of lush surroundings either. Remember, they had a hard time growing crops and stuff inside the concentration camp, so they couldn't really, the government had to provide food and stuff, so it wasn't exactly like this was a great situation. Obviously, anytime you're denied your freedom, that's not an ideal situation. Korematsu, like I said, sued, and the Supreme Court actually said that the United States was okay to do this. It was well within the Constitution because they were protecting the national security rights of the United States. So that's what the Supreme Court said. Obviously, I think as history has kind of unfolded, as we look back, that was, definitely a black mark on kind of U.S. history. The fact that we did it in general, the fact that Franklin Roosevelt issued that executive order to put Japanese Americans in internment camps was a big black mark on his record and a black mark on U.S. history. But the fact that the Supreme Court, like when they reviewed it, sanctioned it, saying, oh, yeah, that's well within the rights of the Constitution, that's a little bit of a double whammy. It was a tough one. In the 1980s, President Ronald Reagan actually offered an apology to Japanese Americans and offered some financial compensation for potentially lost businesses and the lost business and wages and homes, and I'm sure it didn't really make up for the amount of money that they lost, but at least it was something, I suppose. So again, you can tie those last three into an argument about equality. There's probably other cases we've gone over, but again, I highly doubt that you are going to be called on to use those. I think these are 5 that really stick out for sure. If you have any other questions or comments, please feel free to contact me. If you have any suggestions about making videos, absolutely feel free to let me know. I'm game to talk about whatever you want. So until next time, I will see you all later.